brief, U.S. Civil Liberties Authority from God through U.S. Code and courtesy notice to officials about criminal penalties and civil liabilities they have incurred in breach of federal civil rights statutes under authority of the U.S. Constitution per its natural law of nature's God. Well, folks, as we went through this in the first segment, we got down to the point of actually applying these civil liberties statutes that are federal statutes that are always senior and never subordinate to any other custom usage regulation ordinance or any other law or statute, anything. And where this all begins, folks, is in 18 U.S.C. 242, section 242. And as we discussed, this is paired in the case of conspiracy with section 241, criminal conspiracy against rights, 18 U.S.C. section 241. But the actual description of the crime, a felony offense, which I believe, Audra, based on everything that you and Sean have demonstrated, the San Diego County Board of Supervisors are guilty of, and they stand in a continuing state of felony offense against the people of all 3.4 million residents of San Diego County. And that falls under 18 U.S.C. 242, deprivation of rights under color of law. Whoever, and that means Supervisor Desmond, Supervisor Vargas, Supervisor Anderson, the sheriff deputies, if they're participating in it, the sheriff of San Diego County, if he's participating in it, the drive-through clerk at McDonald's, at the cash register, a citizen walking the street, a pastor in a church, an elected official, a plumber, anybody, whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. Remember how that sounds very much like Article 6? It's meant to. That's where it comes from. Or to different punishments, pains, or penalties on account of such person being an alien or by reason of his color or race than are prescribed for the punishment of citizens shall be fined under this title or imprisoned not more than 1 year or both. And if bodily injury results from the acts committed in violation of this section, and by the way, if somebody sticks a needle in you or affects your health with making you wear a mask, yeah, that's bodily injury, folks. Committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire. Now, a dangerous weapon includes a taser or a firearm that a sheriff's deputy is carrying in a San Diego County Board of Supervisors meeting. And by the way, brandishing that weapon or unsnapping a holster or pulling out a taser weapon, these are threatened uses, okay? So the sheriff's deputies quickly must understand, and this is where the education moment happens, that as you were exhorting them to rightly, Audra, it's to the people that they are beholden because it's the people's liberty that is prescribed in the Constitution and that is the subject of the oath that they took to preserve, protect, and defend that Constitution against all enemies, foreign and domestic, including county boards of supervisors from coast to coast. And at any rate, threatened use of a dangerous weapon, explosives, or fire shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping. Now, kidnapping, folks, happens quite often, or at least not uncommonly, when a false arrest is made. As an example, Audra or Sean, if a citizen is standing on their liberties to petition their government for redress of grievance under their First Amendment prerogative, and they are seized by sheriffs and arrested from that behavior at the behest of offending County Board of Supervisors, that is a kidnapping. If such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse or an attempt to kill shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. It is a very serious felony offense, folks. And this is the dance that these confused and deliberate, in many cases, public officials have done right across the country from coast to coast. And it appears most especially within the council chambers of the San Diego County Board of Supervisors. And so when two or more persons are involved in these offenses, that becomes a conspiracy against rights under 18 U.S.C. section 241. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping again, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. It cannot be any more serious, folks. That's why these statutes exist, to preserve the people's liberty. Now, as we talked about in the first segment on this, folks, we talked about the walking liberty being a coin that has two faces. On the obverse, we see Lady Liberty walking in her flowing robes, unmolested, in her daily walking liberty, minute to minute, hour by year, decade by decade. And that's what's happened for Lady Liberty in our coinage and in our country. Well, that's been interrupted with this last 20 months of craziness. And so there comes a time, folks, for the people to redress their grievances. And the half of the coin that is the criminal section, as we discussed, are covered by these statutes. But there's also civil damages that accrue to those who are in offense of this, and they are described. And again, this document is at badassunclesam.com, folks. They are described in equal rights under the law in 42 U.S.C., and they are described in civil action for deprivation of rights in 42 U.S.C. section 1983. And they are described in conspiracy to interfere with civil rights in 42 U.S.C. 1985. Let's start in 1983 and say that, again, every person, whomever that be, including supervisors at the County Board of Supervisors, who have already committed felony offense in this, ongoing for 20 months now and more. Again, we knew in March and April of last year that this was never going to be a thing and should not have been treated in the manner that it was. And Jim Desmond and Joel Anderson, shame on them. They knew it, and they kept voting yes to a state of emergency that need not have ever existed, causing untold suffering to the 3.4 million residents in San Diego County. And that's been repeated in the other jurisdictions around the country in the total mammon-centric compromise of our political and our moral ethics in this country. And so each of those is a person. And so they're responsible. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. And so what we see there, folks, is that these folks have assumed for themselves personal liability. And folks, they will not be able to hide behind a shield of director's protection or supervisor's protection on insurance policies, because the Supreme Court in Lewis versus Clark out of Connecticut has already described that there is no defense for public officials who step outside of their authority to abuse civil liberties. It's already decided case law, folks. But furthermore, as we described in the case of criminal penalties above in 18 USC, here in 42 USC in section 1985, we see conspiracy to interfere with civil rights. Now, that can be described in subsection 3 very effectively of 42 USC 1985, which describes depriving persons of rights or privileges. By the way, the beautiful thing about these statutes is the language takes you to the result. If two or more persons, again, in any state or territory conspire or go in disguise on the highway or on the premises of another for the purpose of depriving either directly or indirectly any person or class of persons of the equal protection of the laws, or of equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within such state or territory the equal protection of the laws, or if two or more persons conspire to prevent by force, intimidation, or threat any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress of the United States, or to injure any citizen in person or property on account of such support or advocacy in any case of conspiracy set forth in this section. If one or more persons engage therein do, or cause to be done, any act in furtherance of the object of such conspiracy, whereby another is injured in his person or property, or deprived of having and exercising any right or privilege of a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. Which means that every single county employee that's involved in this, including Dr. Wilma Wooten with all of her fictional nonsense statistical stuff that becomes the Ministry of Propaganda supporting this outrageous abuse of civil liberties in San Diego County, she becomes accountable to this as well. And furthermore, folks, we see that the code provides, the US code, for folks who, knowing better, should have done something about it, you know? And it's called action for neglect to prevent. And when we see what that statute reads, it's more of the same. Every person who, having knowledge that any of the wrongs conspired to be done, and certainly Jim Desmond was given full warning about this, not just by parties in this conversation, but by others over the course of the last year and more. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured or to his legal representatives for all damages caused by such wrongful act, which such person by reasonable diligence could have prevented. And such damages may be recovered in an action on the case. And any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. And if the death of any party be caused by any such wrongful act and neglect, the legal representatives of the deceased shall have such action, therefore, and may recover not exceeding $5,000 damages therein for the benefit of the widow of the deceased, etc. But no action under the provisions of this section shall be sustained which is not commenced within 1 year after the cause of action has accrued. Well, there's still an ongoing violation of this stuff, folks. So the clock keeps resetting until they end their state of emergency, like yesterday. And then you have proceedings in vindication of these civil rights in courts of law. And that's under 42 USC 1988. And that describes the things that are available to the plaintiffs in these: expert fees, attorney's fees, and other remedies at law. Now that brings us, Michael and Sean and Audra, to the question that we raised earlier in the broadcast and tangentially made reference to, with the leadership coming from sheriffs around the country now, constitutionally minded sheriffs who are elected of the people. And they have great authority, just like any sworn law enforcement official has in this country. In fact, because the preservation of the people's liberty is so fundamental to our experience in this country of self-governance under the Constitution, this is described, their authority, in federally protected activities under 18 USC section 245. And it states, nothing in this section shall be construed as indicating an intent on the part of the Congress to prevent any state or possession or Commonwealth of the United States or the District of Columbia from exercising jurisdiction over any offense over which it would have jurisdiction in the absence of this section, nor shall anything in this section be construed as depriving state and local law enforcement authorities of responsibility for prosecuting acts that may be violations of this section and that are violations of state and local law. Furthermore, folks, under 18 USC 245, we see that there's additional abilities described specifically for the law enforcement officials in subsection C. Nothing in this section shall be construed so as to deter any law enforcement officer from lawfully carrying out the duties of his office, and no law enforcement officer shall be considered to be in violation of this section for lawfully carrying out the duties of his office or lawfully enforcing ordinances and laws of the United States. So folks, we have all the authority that we need for our law enforcement officials who are constitutionally minded to arrest those persons in the moment who are depriving anyone of their civil liberties. I don't care if you're a patrolman from Winnemucca, Nevada on vacation in the Virgin Islands, and you see somebody's civil liberties being deprived under color of law. They are given authority under 18 USC section 245 to arrest the offending person pending charges, trial, conviction, and sentencing. Okay, so how does that work then with the people and their law enforcement officials under federally protected activities, 18 USC section 245? Well, we've got a footnote here to explore that. Let's head on down and take a look at that footnote real quick, folks. And again, this whole document is available to you on badassunclesam.com, right on the home page, on the landing page. Here it is right here. Should citizens in any moment wish to operate their original authority to preserve their civil liberties in any manner as to them shall seem most likely to affect their safety and happiness, folks, that language again is right out of the Declaration of Independence. As memorialized in Article 6, Amendments 9 and 10. Remember, Amendment 9 gives you your plenipotentiary universe of powers that the people have, the rights that they may not have even created or operated yet. Amendments 9 and 10 of the Constitution, and other amendments, clauses, documents, texts, tenets, and letters of their founding, it is within their original authority and plenipotentiary powers to enlist the ready aid, assistance, and support of sworn law enforcement officials in any capacity under such officials' authority described in 18 U.S.C. 245 and other statutes to effect arrests of offending officials or persons per direction of the citizens to end deprivation of their rights under color of law or for any other purpose in pursuance of preserving constitutional liberties. And further, folks, as we touched on the idea of swearing oaths of office, not only as public officials on city councils and county board of supervisors, et cetera, in your local jurisdiction, but also as law enforcement officials. Further, per sworn or affirmed oaths of office, similar to that appearing in Article 2 of the U.S. Constitution seen above, which we reviewed, folks, in the first segment of this discussion, which effectively swears an oath to preserve, protect, and defend the Constitution against all enemies, foreign and domestic. Such sworn law enforcement officials are obligated in constitutional fidelity to their oaths of office to assist the people to the best of their abilities with all diligence in the immediate restoration of their civil liberties and to arrest whomever is depriving them of their liberties pending charges, trial, conviction, and sentencing pursuant to the U.S. Constitution and laws of the United States in pursuance thereof. In pursuance of the U.S. Constitution, which is that grand document, folks, that memorializes our God-given liberties that we learned in the very beginning, comes right down from the Bible of King James in 1611, through the pulpit and pen of patriot pastors on this continent in the 1600s and 1700s, right into the vernacular of our Declaration of Independence, and then carried through with our intentions under divine providence in the Constitution of the United States of America. Folks, here's a summation of penalties that we've touched on, and as we've seen, it's very serious. 10 years to life or death, same, okay? By the way, some of this becomes seditious conspiracy, folks, under 18 U.S.C. 2384. That's a 20-year sentence. And you can take a look at this on badassunclesam.com, and you can distribute this legal brief and courtesy notice to your public officials so that they may become quickly understanding of the liabilities that they have assumed and immediately end the deprivation of your rights, the rights of your families, your fellow citizens, your fellow parishioners, your fellow congregation members, your fellow Americans.
Once again, you did an excellent job of going through this and explaining it. I might add that, to seek the help of the law enforcement by educating, of course, it's their obligation. There are also, every state has a civil rights division. So if you find yourself, your rights being violated, not allowed into a business or restaurant, document this, of course. And you can file a complaint with the Civil Rights Division of each state, with your state, and also with the EEOC, which is the Equal Rights Opportunity Commission, that's federal. So you want to hit all the bases. You want to hit the local police, the sheriffs, county, right? And also hit the civil rights divisions in your state and your federal. So we're covering all the bases here and hit them and just keep on going. And if they don't perform their duties, ask them why. Because then you can point to the provisions in the legal brief and say, it is your obligation. You can see here that our civil liberties or our rights are clearly being broken. So where are you? It's up to you now to go ahead. The ball's in your court. Otherwise, it becomes a citizen's arrest, and then you have to back us up when we do that.
Well, by the way, Michael, that's a good point. The citizen's arrest, folks, if it comes to that, and it may well, The citizen's arrest is the highest form of arrest in the country because that comes directly from the sovereign authority of the people of the United States of America. Remember, folks, government is in 5 branches. God is the sovereign. He delegated the people in the second branch of government his liberty, as we see in Galatians chapter 5. And again, this natural law from nature's God is the way the Constitution is designed to operate, and our founding documents, as we've reviewed in these segments, demonstrates that to us. Well, then the people enumerated 3 junior branches of government, the legislature, the executives, and the judiciary, to run the day in and day out functions of government. But whenever those become unsatisfactory or dilatory in their preservation of the people's liberty, it devolves back up to the people as the sovereign authority to preserve the liberty, and that is done with criminal charges being preferred against offending persons, whether they're officials or anybody else. And I submit, Michael, that civil rights commissions and other things are fine, and that can be done. But the first step is to prefer criminal charges or civil damages charges, or both, in a criminal filing as a complaint with a law enforcement official. And I think probably we're talking about filing with a county sheriff or with federal authorities. But again, per 18 USC 245, any law enforcement official is given the authority to enforce these civil liberty statutes. And again, that's exactly what Audra had done there when she exhorted the San Diego County deputies to engage on behalf of the people, because the time may be coming, Sean, as you say, with your 400 and 500 folks gathering there at the San Diego County Board of Supervisors meetings to say they've had enough of their liberty being destroyed by these overreaching tyrants, petty tyrants, really, that the time is coming when the people will just have to say enough is enough, and they may have to affect their citizens' arrest. Okay?
I think that time is here. That time is here. We're seeing the people rise up, so that time is here. All right, if anybody wants to have any more instruction on this, again, it is Patriot Soapbox, but I digress. Thursday from 10 o'clock to noon, that's Central Standard Time, with the deacon.
I might say, Sean and Audra and Michael, that bottom line on this thing is we've gotten so far away from our natural law under nature's God and operation of the Constitution that what it becomes is an education moment, you know? So the law enforcement officials are going to have to be educated. These county board of supervisors are going to have to be educated. And I know you're working very hard on that, but they just don't seem to be getting it. So there will be repercussions for that on a statutory basis for those who continue to offend. And again, even if they pull out of this stuff now and repent, which they need to do immediately, and restore liberty like yesterday, like immediately, even if they do that, they still have sustained criminal and civil liabilities in this matter now ongoing for 20 months.
It's a war. We're in it. Act accordingly. All right. I want to thank you all for coming by. This has been a wonderful experience. Can't wait to talk to you guys again on Thursday here. And furthermore, and anybody who wants to tune in, I'm sure we're going to be going over more of this. And don't you have is it a possibility that people could ask questions or on the stream? Is that possible when they on Thursdays, or how do you work that?
Oh, yes, it is, Michael. There's a chat function, and we can accommodate comments, suggestions, information, questions as part of the stream. In fact, we might want to focus on that on Thursday for those folks who wish to participate. And this will be day after tomorrow. And then we'll continue to highlight these things so people can kind of get spooled up and help their law enforcement officials to get spooled up. And bottom line is, the liberty is going to be protected one way or the other, and it's going to be happening sooner rather than later. Just like we see already, these constitutional sheriffs are standing tall. They're not going to take our liberty away from us, folks, despite all the machinations and all the histrionics of importuning fraudsters, even in the highest offices of the land. And I might just say, Michael and Sean and Audra, it's been a great pleasure to be with you all here on this stream. And I think it's important work that you're doing. It's an honor and a privilege for me to be able to even be associated with such high caliber patriots. Michael DeBerry, Badass Uncle Sam, Sean Fredrickson, Patriot Extraordinaire and Son of God in San Diego County, and Audra Morgan, Sister of God and Extraordinary Patriot. Just what a blessing for all of us in our country. And thank you so much for everything that you're all doing.
Amen. I think that's a good way to sign off. God bless you all. And
See you guys. Thank you.
Thank you.
God bless.
Yes. Thank you so much.
Thank you.